Assalamualaikum to Miss Haja. My name is Atirah Binti Azhar and my student ID is 2018-695 and 242. I am from group number 2. So, I'm going to explain on the introduction to our court case study. First of all, we have decided to examine the case of Kesatuan Pekerja-Pekerja Lombong, Emas, Pahang against Specific Resources Sendirian Berhad. For your information, this case is involving matters pertaining to collective agreement. So, what is collective agreement? Collective agreement is basically the result of negotiation or collective bargaining done by trade union and employer. Usually, the matters that they discuss in collective bargaining involve matters such as working conditions, employees' wages, overtime payments, and also more. And through this negotiation, this will result in the collective agreement. So, for this court case study, we have used two acts, which is Employment Act 1955 and also Industrial Relations Act 1967. There are two legal issues presented in this case study, which is firstly is whether the employees or the trade union can claim against their employer. And the next one is whether the wording used in the collective agreement are precise in order to avoid confusion. So, the title for our court case study is Look Before You Leap, which means that you need to think before you start acting, which reflects a lot in this case.
Assalamualaikum, my name is Alia Nursyahirah binti Shokeri. My metric number is 2018644846. Now I will present the legal issue in this case. So there are two legal issues stated in this case. The first one is whether the employees union, which is Kesatuan Pekerja-Pekerja Lombong, Emas, Pahang, has claims against the employer, which is Specific Resources Sendirian Berhad, for the non-compliance of the Article 23 and 24 and the refusal to pay 1 hour overtime payment to the mining employees pursuant to the first collective agreement. Collective agreement is an agreement between an employer or employers trade union and employees trade union relating to the terms and conditions of employment. It must be signed, and if there is breach of contract by the employer, the trade union has right to take actions toward the employer. In this case, Article 23.3 stated that the company's operational need must work up to 12 hours per day and the overtime will be paid 8 hours after the normal business day. When we look at this article, the mining department lies under the company's operational needs, which they must work up to 12 hours per day. This means the remaining 4 hours will considered as overtime, which is in line with Section 60A Clause 3 of the Employment Act 1955, which stated that any work that is carried out in excess of normal working hours is considered as overtime. Another thing that we look up in this Article 23.3 is that it was stated that overtime will be paid after 8 hours of normal business day. The company argued that they are not breaching any contract, as it was stated in the article that working hours are 8 hours a day excluding rest time. However, there is difference between business day and working hours. Business day can be defined as the day of business operation are conducted, while working hours refers to the time spent by the employees working at their job. This means the business hour for this company is started from the time where the employees clock in. In addition, the union able to prove their allegation with strong evidence. They provide evidence that in the past practices, the company had paid the employees for 4 hours of overtime payment. In addition, the union also gave contract of employment from one of the employees in mining department for the court to review, where the contract has been wrote that employees will get 4 hours of overtime payment. This situation makes it clear that the company is conducting this action in unilaterally manner, which benefited them only. Thus, this evidence is enough for the court to help that the company should pay the union members 4 hours of overtime payment. So the second legal issue in this case is whether the wording used in the first collective agreement signed between both parties is precise and unambiguous. The union argued that the Article 23.3 of the said collective agreement is not rigid because the wording used is vague and not clear. Based on our understanding, the collective agreement are generally specific in the field of job. However, in this case, the word generally in the opening statement of the Article 23.3 is not particularly and specifically used for the mining department. Furthermore, the application of working hours in the collective agreement is not firm and unclear when the term generally is used when excluding rest time. Based on our understanding, this term made the provision not strong, and it is fine even if it is not followed. Based on our understanding regarding this topic is the wording of collective agreement need to be simple and as unambiguous as possible. The vague term and words used will likely to cause difficulty later in the implementation of the collective agreement. Moreover, the issue arises in this case is when the terms and conditions of the collective agreement is not aligned with the memorandum that has been signed by both parties. However, the company provided an evidence stated that the 3 hours overtime stated in the memorandum is the act that had been negotiated, agreed and signed by both parties. However, when we look at the memorandum and compare it with the Article 23.3, there is no specific wording explained about the 3 hours of overtime claimed by the company. This situation is considered as not the intention of the contracting parties. Last but not least, the issue arises when the collective agreement was less favorable applicable to the employees of the company, which is contradict with Section 14 Clause 3 of the Industrial Relations Act 1967. Which this action shall be void. In this case, it was considered as less favorable because previously the employees were entitled to get 4 hours of overtime payment, but eventually the company refused to pay another 1 hours of overtime payment to the employees starting from 16 March 2018. Thus, it is a thoughtful action that the court has accepted this evidence provided by the union and held that the 4 hours of overtime payment remain unchanged and should be paid to the employees. With that, thank you.
So, I'm going to explain on the acts and sections involved in this case study. First of all, there are 2 acts, which is Employment Act 1955 and also Industrial Relations Act 1967. Let's move towards the Employment Act 1955 first. So, there are 2 subtopics under Employment Act 1955 that we have included in this case study. First, we are going to identify whether the employees is governed under Employment Act 1955 or not. Based on the Employment Act 1955, there are certain categories that need to be fulfilled by workers in order to be qualified as an employee under the Employment Act 1955. So, after analysing the case, we have identified that the workers under Kesatuan Pekerja-Pekerja Lombong, Emas, Pahang are indeed employees because they engage in manual labour, since they are minors. Next, I'm going to explain on the working hours of the employees. According to Section 60A Subsection 1 of the Employment Act 1955, employees cannot work more than 5 hours consecutively without a break of 30 minutes. The next one is they cannot work more than 8 hours a day. And the next one is they cannot work in excess spread of 10 hours and they cannot work more than 48 hours a week. So, after we have read the case, we identified that the employees in mining department have worked for 12 hours shift daily. So, this means that it does not satisfy the criteria in line in section 60A subsection 1. However, after reading the case, we know that the employees receive a 1-hour break from 12 PM until 1 PM, which is in line with section 60A subsection 1. Next, I'm going to explain on the topic of collective bargaining and also collective agreement. According to Section 13 of Industrial Relations Act 1967, collective bargaining is basically the negotiation process between trade union of employer, employers or employees to negotiate on terms regarding employees' working conditions, overtime payments and also wages. In this case, a memorandum has been made between Kesatuan Pekerja-Pekerja Lombong Emas Pahang and also Specific Resources Sendirian Berhad on 7 March 2018. In this case, the memorandum is the collective bargaining. After you have negotiated the terms and conditions in the collective bargaining process, you put it all down in a paper in order for employees and employers to take note. For a collective bargaining to be executed, they need to include a specific execution date, which means that the starting and the ending date and the name of the parties involved in the collective agreement and more. So, based on section 14 subsection 2, the parties on this case, which is Kesatuan Pekerja-Pekerja Lombong Emas Pahang and Specific Resources Sendirian Berhad have fulfilled this section because based on their collective agreement, there is a specific date in this collective agreement. Next, I'm going to explain on the section 14 subsection 3 of the Industrial Relations Act 1967. Based on this section, it is highlighted that if any terms and conditions that is less favorable towards employee side, the collective agreement should be considered void. Which means that if the employers trick the employees or the employers deny employees' rights, which is different than what they have discussed in collective bargaining, the collective agreement should be considered void. In this case, it is very evident that the employers are tricking the employees by manipulating the words in the collective agreement and also by providing less favorable terms towards the employees. This is because the employees are expected to receive 4 hours overtime payment, and instead, the employers only give them 3 hours overtime payment. Next, I'm going to explain on the effect of collective agreement. According to Section 17, subsection 1 of the Industrial Relations Act 1967, a collective agreement is considered as an award, which means that it is legally binding between the parties. For example, in this case, both parties were the Kesatuan Pekerja-Pekerja Lombong Emas Pahang and Specific Resources Sendirian Berhad should not deny the terms and conditions in the collective agreement, and they need to obey it, or they will be fined or worse, imprisonment. I'm going to explain on the effect if the employers deny to follow the terms and conditions stated in the collective agreement. First of all, according to Section 56 subsection 1 of the Industrial Relations Act 1967, if the employers refuse to hear what their employees are trying to say, refuse to reflect back the collective agreement, the case will be brought up to the court. First of all, the employees will file the report to the trade union and the trade union will bring the case to the court. Lastly, next is on Section 56 subsection 2A of Industrial Relations Act 1967. In this section, it is specified that if a complaint has been received by the Human Resources Department or the trade union or even the ministry, the case will be brought up to court, and the court will order the parties, for example, the employers, to comply with the orders. And in this case, it is very obvious that finally the court has to comply with the orders of paying a sum of 4 hours overtime payment instead of 3. Next is on Section 56 subsection 3. If the employer do not want to follow the court orders, for example, in this case, if specific resources would not pay employees 4 hours overtime payment instead of 3, they will be fined or even worse, imprisonment. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Firdaus bin Ahmad Adnan. My metric number is 2018-248076. Previously, we have talked about the introduction and the section or act that are being discussed in the case. What is the conclusion and the court's verdict? So, the case summary is the working hours for the mining department employees is 12 hours starting from 7 in the morning to 7 in the evening, or vice versa. Article 23.3 of the collective agreement states that the working hours minus 1 hour rest time are 8 hours a day, which align with Section 60A1 of the Employment Act 1955, which requires the employees that are work 8 hours consecutively to be given a period of rest not less than 45 minutes. So, in the past, before the collective agreement were made, the company wants their employees to work extra overtime for 4 hours as their nature of business is mining. Hence, the union used this as the reasoning for the condition in the employment contract whereby the employees are eligible to get overtime payment for 4 hours. The company representative said that item 2 of the memorandum dated 7th of March 2018 specifies that the working hours include 8 hours of work and further 3 hours of daily overtime. But nothing has been written or stated that the payment only 3 hours in the memorandum. This is where the problem occurs when the company pay the employees only for 3 hours but not 4 hours. The union representative has been understood that the agreement in Article 23 of the collective agreement stated that the overtime payment of 4 hours work, and there are no suggestion by the union to change it to any other durations than 4 hours. Hence, this further shows that the company must aware of this condition and follow on what has been agreed. Because of this, the court agrees that the union is eligible to claim the overtime payment. The court also instructed the company must comply with the Article 23 and Article 24 of the collective agreement by paying 4 hours of overtime starting from 16th March 2018 onwards. Last and not least, what should any parties do so that the case like this will not happen again in the future? Firstly, complying with the collective agreement. Collective agreement comes from a successful collective bargaining. Hence, both parties must comply on what has been agreed. Like in this case, the company act on its own by giving the employees only 3 hours of overtime payment without the knowledge of the union. So, this unlawful action has given negative impact to the company itself as the case has been brought to the court. If the company just stick to the agreement, none of this hassle will happen. Secondly, use precise wording in the agreement. The wording in collective agreement should be simple and easy to be understood by all parties. In this case, the company representative said that the item 2 of the memorandum dated 7th March 2018 specifies that the working hours include 8 hours of work and a further 3 hours of daily overtime. But the precise and correct wording used in the memorandum is not present. Thus, this further proves that the importance of using precise wording so that no confusion will happen between any parties. I think that is all from us. Thank you. Assalamualaikum warahmatullahi wabarakatuh.